Good morning, everyone. The hour of 9:30 a.m. having arrived, the House Judiciary Committee will come to order. Secretary, please call the roll.
Chairman Briggs.
Present.
Representatives Carroll,
Designation.
Donahue,
Designation.
Hanbidge, Hohenstein,
Designation.
Howard, Kenyatta,
Designation.
Kincaid,
Designation.
Mays,
Designation.
Miller,
Designation.
Pielli,
Designation.
Rabb,
Designation.
Sanchez, Schusterman.
Designation.
Chairman Kaufman,
Here.
Representatives Bonner, Borowitz,
Designation.
Ecker,
Designation.
Ham,
Designation.
Kale,
Designation.
Kerwin,
Designation.
Clunk,
Designation.
Kuzma,
Designation.
Ledbetter,
Here.
Rigby,
Here.
Shalaba.
Designation.
Thank you, Madam Secretary. For the information of the members and those in attendance, this meeting is being recorded and will be available on the caucus's websites. Please silence your phones and please be respectful of all the testifiers. If you are participating on Teams, I don't see anyone on Teams. I want to ask a question. Please raise your hand. Enacted in 1976, the Mental Health Procedures Act established procedures for the treatment of mentally ill individuals, ensuring a balance between providing care and respecting individual rights. Since then, our legislature has continued to champion the mental well-being of all of our citizens, introducing legislation to protect access to mental health medications, support our mental health workers, and show individuals struggling with mental health issues that we have not and will not forget about. My staff, along with Democratic Whip Schlossberg's staff, collaborated on planning of this hearing, and I know this issue is near and dear to Mike's heart. I want to thank John O'Donnell and Rachel Miller for all the hard work they put into organizing today's event. Rep. Schlossberg will be sitting in with the committee, and I would like to recognize the whip for some opening remarks.
Thank you, Chairman Briggs and Chairman Kaufman, the members, the staff, and the testifiers. I'm so grateful that we could all be here today to discuss a genuinely critically important issue to the mental health of Pennsylvania. And I say that because every single one of us has heard the nightmare stories. The person who could not get help, whose family could not convince authorities that their loved one was a danger to themselves or others. We know that well-intended and legal decisions have resulted in people being discharged into the community at large only to hurt themselves or others. More importantly, perhaps, albeit less dramatically, are the people who lost an opportunity to get the mental health help that they needed, sending them further into a spiral of mental illness and costing them time. The voluntary and involuntary commitment system and its related components were first created under the Mental Health Procedures Act of 1976. Amendments and additions have been created to that act, but it has not seen a wholesale overhaul since it was first created. I would argue that this is unacceptable. The act is so old that it uses words like mental retardation to describe the mentally ill. More importantly, is that it was created for a system that no longer exists. When state hospitals were robust but acted as warehouses for the mentally ill, when ERs were not bursting at the seams with people waiting for a bed for an inpatient facility, and when the largest mental health care provider in the Commonwealth was not our prison system. Broadly speaking, I think there's two areas that need to be examined in the 302 system. The first is largely technical, but vitally important concerns. These are operational concerns, including terms and definitions, timing, uniformity of procedures, and more. However, I think it's also worth examining the circumstances in which a 302 can be executed. We have a moral and legal obligation to ensure that involuntary commitments are rare and only done in the most necessary of circumstances. At the same time, other clinical factors, including previous treatment history and the potential for severe psychiatric deterioration, may be appropriate items to consider and have been considered in other states. Let me close with this. I do not believe, truly do not believe, that this is a partisan issue. All of us, Democrats and Republicans, have loved ones, friends, or constituents who have needed help but are unable to get it. The fault lines here won't be Democrat or Republican. The issue falls along a more classic spectrum. When does an individual's right to make healthcare decisions on their own stop and society's interests become more important? I do not know the answers, but I look forward to learning more about them. And thank you, Mr. Chairman.
Thank you, Whip Schlossberg. I also look forward to hearing from our testifiers, and I sincerely thank everyone who took the time to submit written testimony as well. We're going to go to panel one. You're all here together, but each testifier will be given approximately 10 minutes to speak, and we will have questions and comments following each of the two panels. Our first panel today includes Judge Henry Hillis from the Court of Common Pleas of Montgomery County and Judge Charles Ehrlich from the Court of Common Pleas of Philadelphia County. Judges, please begin when you are ready. Judge Hillis.
Is this on? There we go. Chairman Briggs and esteemed members of the Judiciary Committee, it is my pleasure to be here testifying with respect to the Mental Health Procedures Act. I did submit prepared remarks. If anyone happens to be following along, I read through my remarks last night and realized it was about 2 times the allotted time period. So I've pared it down a bit. The Mental Health Procedures Act has served our Commonwealth for approximately 50 years. The Act is important to our state and county systems. I am the administrative judge of the Montgomery County Juvenile Division. I also preside over the county's Behavioral Health Court and Competency Court. I make or hear references to the Mental Health Procedures Act on a daily basis, in and out of court. It has become increasingly clear with the passage of time that the Act can and must be modified and improved. Issues within the mental health and criminal justice system have continued to evolve while the Act, for the most part, has not. It has become more difficult in court to ascertain legislative intent when trying to apply the Act to situations I see in court every day. In short, the Act has become dated and needs our attention. I salute the government leaders and stakeholders that are undertaking this significant project. I believe it is appropriate and necessary to both protect our communities and service people with mental health challenges. I'm going to highlight some issues I think should be considered. First of all, as was mentioned, we certainly need to modernize the language of the Act. That's some low-hanging fruit. But the very first substantive section of the Act references persons who are mentally retarded, senile, alcoholic, drug dependent. The Act, of course, loses moral legitimacy and credibility when it uses words that are no longer accepted in the medical and legal communities. I suggest that we make it clear whether Article 4, which is the forensic section of the Act, applies to juveniles. Article 4 applies to the examination of treatment of people with mental health issues who are charged with a crime. The Act is silent with respect to whether Article 4 applies to juveniles. This causes debate and confusion in the juvenile justice system where I preside. Here's the confusion. Incompetency, as defined in the Act, applies to a person who has been charged with a crime and otherwise meets the definition of incompetency. A person determined to be incompetent to proceed may not be tried, convicted, or sentenced. Well, the issue is that these are all terms that are not used in juvenile court. Pursuant to the Juvenile Act, a person charged with a crime is charged with a delinquent act. A trial is a denial hearing. If a person is not found guilty in juvenile court, they are adjudicated. They are not sentenced, there's a disposition. So there's an argument that on its face, the Mental Health Procedures Act does not apply in juvenile court. And indeed, the title of the Article 4 is Determinations Affecting Those Charged with a Crime or Under Sentence. The only mention in Article 4 to juveniles is in Section 401C, which provides generally that the civil provisions of the Act apply to juveniles, but it's silent on the forensic provisions. And I'll say this, this is not an academic exercise. At the Juvenile Court Judges Commission, they have a seminar every other year, a multi-day seminar that's very well attended. Last year, one of the 90-minute sessions was the question of whether the Mental Health Procedures Act applies to juvenile court. And literally, some of what we were talking about is how can we come up with a rationale for why it does. It would be very nice to judges in the court system, of course, if the legislative intent was clear in a reworked act. I do suggest, and I know this has been discussed before, expanding the act to address people with substance use disorder. Substance use disorder is a mental illness recognized by the DSM-5 in gradings from mild to severe. Our understanding of this disease has increased tremendously since the act was created. I believe that excluding people with severe level substance use disorder and their families from the protections of the act conflicts with current psychiatric standards and understanding. Substance use disorder is a disease that kills thousands of people every year. As the administrative judge of the juvenile division in Montgomery County, here's the real frustration I see. Every month, I see babies, newborn babies, who are born addicted to heroin and other illegal drugs. And the reason, of course, is that their mothers have substance use disorder and were using drugs during the pregnancy. Every time I see it, it's horrible and unbelievably frustrating. And yet, there's nothing families can do, because if a pregnant mother has substance use disorder, the families cannot use the act to try to seek involuntary help. And my argument is that should be reconsidered. I would like to see, as a judge, increased consistency within the act. There are multiple areas of the act where various provisions appear to contradict one another, and it makes it very hard to follow the law. One example is with respect to court-ordered evaluations. These are people charged with a crime. Section 402E and F provide that the court may order a psychiatrist or a licensed psychologist to conduct a competency evaluation. Section 403C provides that if a person is determined to be incompetent with evaluation number 1, they shall be re-examined not less than every 90 days, so meaning 90 days or more, by a psychiatrist. So the initial evaluation, it can be a psychologist, and almost always is. The follow-up must be a psychiatrist. And there are multiple practical problems with this. One is you now have a different evaluator conducting the evaluation, so if there's a different conclusion, you have one side or the other saying, well, wait a minute, we need another evaluation. And of course, the second evaluation was done by someone who hasn't followed the trajectory of the individual. The other problem is that it is expensive to have a psychiatrist conduct a competency evaluation. There are fewer psychiatrists by far than psychologists, and it's expensive. This is an important issue. This is tremendously costly. I'm faced on a daily basis frequently with lawyers saying, well, we agree to use this psychologist. So then the question becomes, do I accept that agreement and save the county $5,000, or do I follow the law and insist on a psychiatric evaluation? I find no reason that we can't have the same language, that a psychiatrist or a licensed psychologist can conduct that investigation. So that's my recommendation. A second example also involves Section 403C, which provides that a person determined to be competent shall be re-examined in 90 or more days after the last evaluation. Well, this time frame is problematic when someone is subject to involuntary treatment under Section 304G, which many people are who are charged with a crime. If under 304G, a person is subject to court-ordered involuntary treatment for up to 90 days. Well, frequently, what the court system is trying to do once that 90-day period elapses is to determine, does the person need to be readmitted? But we can't have them reassessed until after 90 days, according to 403C. So I would ask that any reworked act look at that time frame, because it's illogical. Obviously, we want to see the reevaluation so that we know whether a person needs to be recommitted. I suggest expanding Section 7111 relating to confidentiality to include probation officers. Section 111 of the Act provides for the confidentiality of mental health treatment records. This section safeguards the mental health records of people subject to the Act. Obviously, it's a very important provision. There are a few, and only a few, enumerated exceptions, people who can see these mental health records. Supervising probation officers are not included as an exception, and I believe this is a mistake. Courts expect probation officers to appropriately supervise probationers so that they can promote mental health, rehabilitation, and of course protect the safety of the public. A query how a probation officer can do that most effectively if they do not have access to the mental health treatment or the recommendations of mental health practitioners. The Act handcuffs the very people that we want to help our people on probation suffering from mental illness and protect the public. So I would ask that that be looked at. Like many people, I believe the Act needs to be revised and modernized. However, I feel I'd be remiss if I didn't mention the need to focus on providing additional resources for people with mental health issues. The system needs these additional resources, more treatment facilities, more beds, more treatment professionals. Devoting more resources to mental health treatment benefits those suffering from mental illness, their families, and society as a whole by making our communities safer. We all see on the news and in our communities what can happen when the system lacks the resources to connect people with mental health treatment. Ultimately, as a society, we pay for mental health challenges one way or the other. We could certainly try to make this payment up front so that we can help people and keep our communities safer. One example of how the lack of funding has undermined the Act, Section 304C provides for assistant outpatient treatment, AOT, and permits the court to order persons to be examined by a psychiatrist or other qualified professional. The hope, of course, is that we can get these people help. Problem is, it takes a lengthy period of time for an individual to obtain a court-ordered evaluation and/or recommended treatment. Meanwhile, the individual continues to suffer. There's no follow-up. So the reality is, without the proper funding, these provisions and court orders are, in a real sense, aspirational and not realistic or meaningful. I suggest, in looking at this act, humbly, that we as stakeholders try to envision the system that we want, how we want to treat people with mental illness, and then rework the statute after we have that vision. I'd love a system where the civil and forensic sides of the act work together. For example, if a person is subject to an AOT order and the police are called, which we see every day, the police could see the AOT order and file paperwork that would get the person in front of a hearing officer with some authority to require treatment. This would help adjudicate the matter in the civil arena where we're focusing on help. What ultimately happens is the police frequently end up with no other option. They file charges. When we end up clogging up the criminal system, the individual gets no help. I would urge us to look at that, or perhaps require a person subject to an AOT order to have to come back to see a hearing officer. That would require investment into the hearing officer programs, but that would provide follow-up, and follow-up is so key. That's why all treatment courts, I preside over the behavioral health court, but that's why treatment courts and diversion courts work, because we have follow-up, and we don't have that under the Act. The Mental Health Procedures Act is an important document. It needs to be modified to remain relevant, to evolve with our changing landscape, and provide additional clarity to stakeholders, courts, and our communities. Again, I laud the members of the Judiciary Committee and all the stakeholders for investing the time and energy to closely examine and improve this Act. Thank you very much.
Thank you, Judge Hillis. Before we go to Judge Ehrlich, I want to acknowledge that we are joined by non-members of the Judiciary Committee, but I mean, all the members of the Judiciary Committee are the top, but we're represented by a couple great members. Justin Fleming, Durisha Parker, and Kristen Marcel have joined us as well to be listening in. So thank you, Judge Ehrlich. When you're ready, you can begin.
Thank you for having touched on way of background set up mental health. And the reason threatened me, said go file a private. Neighbor is acting erratically. Nobody can do it. Is that better? I'm sorry. When the police arrest, that we require, in cases where we know that there are mental health issues, a psychiatric examination. We hold somebody for 3 days, and we went into a special court with a special judge to see what's needed to be done. And a lot of these cases could be dealt with without even further criminal prosecution but rather requiring treatment. And I think the other issue with the criminal and the civil system, in all honesty, is the civil system has no teeth. And the problem is that in the criminal system, we are the default. We're the default on drug and alcohol treatment. We're the default on mental health. Why? Because we can put people in jail, and we have the keys to the jail. Now, I don't want to put people in jail if I can avoid it, and you have to deal with individuals, defendants who have these problems in a different way than others. But the reason people go to treatment, it's no real secret. Some people, they hit rock bottom, they want to change their lives, is because they know what the alternative is, that they'll get the treatment in the county prison. And that's an issue of how to follow up on what Judge Hill has said about the civil system working better with the criminal system. We are the default for a lot of mental health treatment. And the mental health treatment court set up in Pennsylvania, we have one in municipal court and one in common pleas court, one is pretrial, one is post-trial, have been very effective in combining the resources and having a judge who understands this. You have to understand people. You have to work with these people. It's not a magic carpet ride. And there are things, in addition to some of the technical things that we can do to improve the act, and Judge Hill has touched on it, and we shouldn't have like one section 400, another section 300. We're jerry-rigging the commitments, to say it's 304 via 402B. There's very little actual legal authority, and it shouldn't be that way because the act was written in a different time. However, we must require mental health providers to report to the court if things are not going as ordered. And that is not required necessarily. They have to understand that if we're going to help people move forward, it has to be part of the requirements that are put in there. And I also think that we're going to have to look at the issue of competency restoration. There is a case, Commonwealth versus Humphreys, where if you can't restore somebody, the question is, do you withdraw the charge? And what to do about something like that. The issue of people with intellectual disabilities. And these are funding issues. These are state hospital issues which are not equipped to do it. But the other part of it is that when you look at the act and some of the specifics, there's confusion about when does, for example, involuntary commitment start? When does the 120-hour window start? These are things that can be dealt with. The issue of staying criminal proceedings under Section 403. The issues of 405 and examinations to aid sentencing. The point of all of this is that the act can be substantially improved that will both promote people moving forward in public safety, because that was always our issue in setting up treatment courts in Philadelphia. We had to assume that somebody was not going to take their medication and go out and do something horribly. And then people would say, well, why did you have them in the mental health court or the drug treatment court or the DUI treatment court? And we would have to say, we had them there for these reasons, and these are the checks that we have in place to monitor properly. Nothing is 100% foolproof. So you want to make sure that you have the right systems in place, and that goes back to the remarks that I made regarding providers, to require them to let the court know or a hearing officer know if somebody's not going to treatment, not on their medication. That's the crucial thing. And if you get people to take medication and you get people to get into treatment, and I see them 6 months later, I'm in the criminal court, I'm in homicide now, I don't have as many of these types of cases, but I sat in major trials for 10 years and had a lot of people who would come back after they were on supervision 30 days, 60 days, 90 days. You start to see differences. And 6 months later, you see a lot of differences. But again, sometimes there'd be slippage. It's not a magic carpet ride. But if they know you're working with them, and that's the importance of having mental health courts with specially trained judges, and we try to encourage all of our judges in Philadelphia to work with people, especially that first year when they're under supervision, because that's the year, if you can get them through the first year, you're on your way. With that, I'll be glad to answer any questions.
Thank you very much, Judge. Let's see, are there questions now, or do folks want to wait until we're done all? Any questions for the two judges? Okay, let's continue to panel 2, and then maybe all 4 of you, if there's questions, can tackle them. Our second panel today includes Dr. Clarence Watson, Professor of Psychiatry at the University of Pennsylvania, and Pamela Howard, Mental Health, Development Disabilities, and Early Intervention Administrator for Montgomery County. Dr. Watson, if you could begin when you're ready, I'd appreciate it.
Yes, thank you very much, and thank you for having me present today around this very important issue. My perspective comes from that of a clinical psychiatrist, as well as a forensic psychiatrist who with individuals who are suffering from severe mental illness, and that perspective of being able to see long-term, retrospectively, how an individual might decline over a period of time, and whether or not the system to be. So with that as part of the academic, 17% of all jail detainees have a serious mental illness. More so female offenders at 31% and 15% for male. In 2018, there was an estimated 10.3 million arrests, indicating that more than 1.7 million involved people with serious mental illness. About 3/4 of those individuals also had co-occurring substance use disorders. As pointed out earlier, the idea that there's this artificial line between mental illness and substance use disorders clinically makes no sense. We see that these are partners clinically, often exacerbating one or another, and so artificially separating them really does not make sense from a clinical standpoint. And so there is, along those lines with that substance use disorder, also an increased risk of having contact with the criminal justice system. Each day, we have approximately 380,000 persons with mental illness incarcerated across the United States. And to that, there in 2016 were only about 20,000 civil state psychiatric hospital beds to match that, right? So we have this mismatch. We think about this in terms of the Olmstead decision, the Supreme Court decision in 1999, which came after the draft of our Mental Health Procedures Act that says that these individuals with severe mental illness should not be institutionalized, and that we have to create reasonable accommodations for these individuals to live in the community, and that is important. The problem with that was that there was not a clearly developed catcher's mitt in the community, right? These individuals being sent and transferred into the community with a difficult and rapid demand for creating community programs, again, created a mismatch and a catcher's mitt that was a bit leaky. And so we look at these decreased community services and resources around that, allowing some individuals with severe mental illness to fall through the gaps in our community system, and this leads to a revolving door. That revolving door involving emergency psychiatric services, acute hospital admissions, homelessness, criminal arrest, and then so on and so on. And our Mental Health Procedures Act, as it is written today, doesn't do anything to stop that revolving door. It has been argued that the result of all this is the criminalization of mental illness, where treatment for individuals with severe mental illness has been shifted from community-based systems to our correctional system. Well, we sort of alluded a little bit to how this works, right? I fortunately was a part of speaking with the Philadelphia police department when they were putting together a co-responder model for crisis intervention in the community, especially given some high-profile tragic cases in the area. And the conversation with the police at the time made it very clear. Police are aware when individuals are in need of mental health treatment. When they see them and encounter them on a regular basis in the community, they want to do the right thing, and that is to take them to receive treatment. But the problem is that there are certain limitations around the Mental Health Procedures Act requiring dangerousness, a criteria for dangerousness for individuals who are refusing treatment. And by the way, when we say these individuals are refusing treatment, they are refusing treatment during a time where they're acutely symptomatic. And a part of their symptom happens to be the lack of judgment and recognition that they are in need of treatment. And so we're leaving it to them to make that decision about whether or not they need treatment. And then we also bind the hands of our police officers who either don't have knowledge of available resources, or there's a lack of them. And so they go to the emergency departments and hope that something can be done there, that this individual can be connected into treatment. But what happens there is that individual does not specifically state something dangerous or does not engage specifically in dangerous behavior. There's nothing that could be done. And what does the police officer say after that? Well, they say, I'm frustrated because I took him to the ER yesterday, and the next day I see him back on the same corner doing the same things. And so now we have individuals and police officers who have to decide, is it better for me to wait in the ER for an extended period of time trying to get this person into treatment, but then we find them back on the street the next day, and the next day, and the next day, and we don't know what to do? Let's cut through it and get this individual the treatment that they need by arresting them. Let's get them some charges. That way, that individual can receive the treatment that they need. And by the way, family members who are contacted by that individual on the other end say, hey, listen, family member, I'm in jail right now, would you bail me out? Family members are saying, we've been trying to get your treatment forever. This is the only way we could get your treatment. We're not going to bail you out because you need to stay in there so you can get the treatment that you need. And that's a problem. We have to be able to do better. And so one of the issues here is that the idea that we will be able to provide treatment in the correctional system comes from this idea of, and this is not my term, therapeutic jurisprudence, right? That we can't get them treatment in the community, the police officers do their part and arrest, and then it goes down the line with our attorneys and our judges and everyone trying to do the right thing in terms of connecting the person to treatment, because the purpose is not to punish the individual. The idea, many of these cases don't go forward with prosecution because folks just want this individual to be in treatment versus punishment, especially around low-level charges. I'll share my experience, worst-case scenarios. As a forensic psychiatrist, I am called either by the prosecution or public defenders to perform evaluations for mental health defenses or not. And part of that, I have the opportunity to review the discovery that is shared with me around evidence around the case to make these determinations. And unfortunately and tragically, there are times in which I receive body cam footage from police officers who responded to a residence days before the event, where family members, parents have said, I need my son to hit treatment. He's decompensating, he's not taking his medications. He's been getting worse and worse over time. There's a very clear pattern of noncompliance and police contacts in the past, as well as psychiatric hospitalizations and such. So you take that individual to the emergency department, and that person is either released or the police say, based on what we know this local ER does, there's not anything we could do unless he's said or has done something dangerous. And unfortunately, within days, sometimes, there is a second call to return to that residence, and now it is a homicide scene. And this is a problem. And that problem is compounded by the fact that when I get to see that individual in the correctional system after they've received treatment and they're back to themselves, now they have to live with what they've done to family members that they never would have done if they had the treatment. They're living with the grief and the consequences of severe charges when there would have been, and I see it all the time, various points along the course of intervention where something could have been done, but the system has those gaps, and that family, unfortunately, fell victim to that. And so, here are some possible potential solutions around this, at least in my mind as a clinician. I leave the work to the folks that do this regularly, right? I think that we have to really take a look at our criteria around dangerousness and the way in which we interpret that in the Mental Health Procedures Act, and make a determination as to whether or not we need to do more around providing some sort of standard that allows the consideration of preventative care, right? Preventing the danger from happening, not waiting until the person is so impaired and so symptomatic that they're imminently going to engage in this dangerous behavior, because we know the course is likely given that person's history. And so being able to say that this person is likely to decompensate to the point that they would become dangerous, given their history, given a history of noncompliance with treatment, that there is some way to intervene. Does that intervention need to be an inpatient hospitalization? Not necessarily. If we talk about assisted outpatient treatment that is on the books but doesn't have teeth, there's not any resources behind it, there's not the available necessary ways to intervene early and keep that person in treatment and the follow-up care. The way that we operate now with this criminalization is that we have folks come through the mental health system to get them connected to treatment. Once the court is out of the picture, the person is often lost to treatment. And then we find them back in the system again and again and again. And so I certainly appreciate the opportunity to speak from a clinical sort of standpoint, and I'm happy to answer any questions. Thank you.
Thank you very much. Very, very valuable. Pam, if you want to begin.
Sure.
Is that okay? We can just
I think
pull that
so.
other
Is it
one over.
working?
Can you hear me?
Yep, we can hear it. Thank you.
Judiciary Committee. I'm speaking today on behalf of the Pennsylvania Association of County Administrators of Mental Health and Developmental Services. Our organization is known as PACA. And I'd really like to thank you for this opportunity to speak with you today about the Mental Health Procedures Act, which is one that plays an extremely critical role for individuals, children, and families on what can be the most challenging days of their lives. Just to give a little bit of background, our organization, PACA, serves as a membership organization that supports counties in their role and responsibilities related to public mental health and developmental services. Today, as we speak about mental health, it is important to understand that the funding for public mental health services comes mostly from the state to the counties, and the counties contract them with local service providers. Clinical services are also funded through Medicaid, which those dollars are mostly provided by the state as well, and that counties are responsible for providing emergency services. And this is a responsibility that's outlined in both the Mental Health Procedures Act as well as the Mental Health and Developmental Disabilities Act of 1966. Involuntary mental health civil commitments are among the most complex and sensitive tools in psychiatric care, where the rights of the individual must be carefully balanced against the need to protect life and well-being. At their core, these interventions aim to prevent harm when a person is in the throes of a mental health crisis that impairs their judgment to the extent that they may pose a danger to themselves or others. Stepping in can be both life-saving and necessary. An involuntary commitment can begin to provide hope for an individual's family and their loved ones. At the same time, involuntary commitments must be approached with caution, respect, oversight, as the deprivation of personal liberty, especially for vulnerable individuals, carries its own trauma and long-term consequences. From a recovery-oriented perspective, autonomy is a critical component of mental health healing. People must be seen as more than their diagnosis, and their voices deserve to be heard even in the midst of crisis. Effective systems of care strive to ensure that any use of involuntary commitment is both a last resort and a bridge to compassion-driven treatment that prioritizes dignity, empowerment, and re-engagement with life. When individuals are supported and not just contained, the path toward healing becomes more accessible, especially when care is continued beyond the initial crisis through therapy, community support, and access to housing, employment, and purpose. PACA is broadly supportive of revising the Mental Health Procedures Act. The act is very old, as we've all kind of noted here today. An interesting thing from where I sit in my perspective is, the counties are very much at the front end due to the responsibilities of the act. And we really appreciate all of the feedback that has been collected by Representative Schlossberg and his team, because I think it did include a lot of stakeholder feedback, and I think that's really important to the process because it does involve family members, who really are trying to help their loved ones in the throes of crisis situations, but also people themselves, people who have experienced involuntary commitments and what that process is like for them. And I think that's very important feedback, and I appreciate all the work that was developed. And I would like to recommend that as it goes forward, that a lot of stakeholder input is continued. I'll focus for you today on a couple of the particular areas that PACA would like to focus on. And again, these are some technical areas because that's our area of responsibility. I'm just going to reiterate the language in the Act is very outmoded, and I think as was noted that it can be offensive at times to people. So I think that's very important to think about in the modernization. There is also some standardization that would be very helpful in terms of the forms and the packets. I think emergency rooms who are trying to move people out of emergency treatment into care, it would be very helpful to have standardized forms that different treatment facilities could just know what they're looking at. They get everything that they're needed, and that could help to expedite moving people along from emergency care. There's a lot of challenges in terms of jurisdictional responsibilities between counties, and it would be helpful to have some clarification there. Counties interpret this differently. So whether it's the qualifying conduct, where the person is located, the location of the treatment facility, these are things that would be helpful to have in terms of standardization in the Act. Another important consideration is that there's components of treatment now, as my colleagues here were speaking, it's a different system, and people live in very highly supervised settings in the community, and it would be helpful if the Act spoke to some of those resources as well, like residential treatment facilities for adults and long-term structured residences, known as LTSRs. These are things that it would be helpful for the Act to really speak to specifically, whether it's outpatient or inpatient kind of care in those settings. It also would be helpful if the Act could establish whether it's a single practitioner, a single physician or provider that can be both the petitioner and the evaluator. The current guidelines on this are unclear. It would be both rights protective and helpful to emergency service providers to know these things. There's also a national workforce shortage of psychiatrists, and the Act could mitigate some of this challenge by authorizing other specific professions, such as certified registered nurse practitioners, to hold authority to compel involuntary examination or to conduct examinations under well-defined circumstances. And then another technical aspect is how transportation works within the Act, and it would be helpful to have clarity in reference to who exactly can transport and under what situations. Especially too, there was a newer act, Act 65 of 2020, which speaks to consent for the treatment of minors, but the transportation aspects in that act are not clear, and we don't want people to have to default to a 302 to have the clarity about transporting a minor. So, because, you know, again, involuntary commitments are the last resort, so if there's already consent for treatment, we don't want the transportation issue to have to default to a 302 for a minor. I'll note that the Mental Health Procedures Act is one that is very, very technical and very complex. And I think that, you know, a recommendation that I would make is that there does be more work that really pulls in experts to parse out not only what the changes need to be, but the systemic implications of change. I think, you know, we can see places where the act was changed in 2018, but it hasn't been able to play out in our system in the way that it was intended to be. And I think a lot of this really speaks to also the need to kind of think about, once people are committed, what are we committing them to? What are the expectations for a system of care that can really support the outcomes that we're looking for? The county MH administrators across the state are grateful, very grateful, for the dedicated individuals who work day in and day out in the crisis space. And this includes law enforcement officers, county delegates, county crisis workers. It's such a truly critical that families, individuals, and children in Pennsylvania have access to true quality crisis services. It would be helpful to be able to have quick and easy access to all bulletins and case law in one place, perhaps on the internet, to help people who need information in determining how to enact all of the technical aspects of the act. And I think as I'm sort of, you know, closing down the end of the panel here, I really appreciate what Judge Hillis said about the notion of envisioning the system that we want, envisioning a system, the way that these two systems can interact together to both be providing the services and supports and the care and the protections and the safety, and to work to really keep people out of the criminal justice system as well. So I really appreciate the time and the care. Another aspect that I just want to highlight too is thinking about you know, some of the services and supports that could really be helpful in the mental health system to engage people. And I think that Montgomery County was one of the very first counties that really worked to help to bring peer support into the Medicaid system. And I would be very remiss today if I didn't mention peer support as an aspect of how we can engage people at all parts of this in their interactions with the mental health system, whether it's working to try to engage people into care, or it's working to try to get people out of the criminal justice system, and it's working to help people understand how they manage their health and wellness, you know, and live the lives that all of us would want in the community. So I thank you for the time, and I really encourage much more thought and deliberation about the complexities of this act, and I appreciate you having us here today.
Well, it's great to have you with us. Before we get to questions, I want to, since roll call, we've been joined by Representatives Rigby, Kenyatta, Hohenstein, and Schusterman. Are there any questions for the four panelists? We will go to Whip Schlossberg.
Well, first of all, thank you all so much for your expertise. I sincerely appreciate your insight as people who deal with this on a regular basis. Arguably, much of the technical things, I think, are relatively non-controversial, and I don't think would be a problem. I think the challenges legislatively start to arise when you start having conversations about scope and circumstance, when a 302 can actually be initiated. Dr. Watson, I'd like to get a little bit more insight into some of your comments. You were discussing situations, and they're the tragic ones that I was referring that we've all seen or heard about, where somebody is clearly experiencing psychiatric deterioration, is losing touch with reality, is unaware that they're losing touch with reality, but because they don't meet what I would argue is an artificially high standard of dangerousness, they're unable to have a 302 executed and winds up becoming a serious problem later down the line. Can you talk a little bit more about how we could potentially change the act in order to reflect those circumstances, as well as some of the benefits and the obvious drawbacks?
Certainly. Thank you for your question. So the act as it is written now, I think, is important to keep in place, right? Clear situations in which there is dangerousness is I think, a way in which you balance patient rights against, the issue of autonomy and protecting society and that person. But the other piece of this is that there are individuals who have a very clear history, a history that does not always necessarily clinically come into consideration in terms of how the person is behaving today when we do these evaluations. So I may have an individual who comes to an emergency department who has a long history of problematic behaviors in the community and decompensates because of not complying with medications, not adhering to their medications and such. Family comes and says, this decompensation is rapid, we know where this is going. Until that person is actually shown some sort of clear evidence of dangerousness, that historical information does not yet necessarily carry the day. And there are other considerations that are now outside of clinical considerations, outside of the clinician's options, right? Because it's usually a person comes to the emergency department, either I'm going to send this person into an inpatient hospitalization, or I can't, and I'm going to refer you to make an appointment with your primary care physician or some other, person within, a couple of weeks, and we know those couple of weeks and wait lists and all those things, it makes a little sense. And so having the ability to be able to refer someone to some sort of outpatient, if that person has something in the community, or some sort of lower level community-based secure facility that allows for observation for a period of time to ensure that person is re-engaged, stabilized, is something to be considered. I would, and thinking about it from the cases I've been involved in, there have been numerous individuals who, if they had a pause, just a tick, in a clinical setting, their family members would still be alive. And there have been too many cases where it just didn't happen, and again, police come and there's been a terrible outcome. So I think that when we are worried about this person's history, I think another piece of this might be, a history of clinical contacts, contacts with law enforcement based on their mental health history. So, police and others having the ability to have a place to take that person based on the history of contacts with police, and make it easy for, and this is more resources and community-based sort of programming, where police officers feel that there is a easy, friendly, user-friendly way for me to be able to put this person into the course of treatment without necessarily involving the criminal justice system. Somehow building that in, I think it becomes important.
Representative Rigby.
Thank you, Chairman. Thank you, testifiers. Doctor, I dealt with, in law enforcement, a young man who would feel great and would quit taking his medications. I was fortunate because when he would go south, he would deal with me. He trusted me. I could work with him. The frustration comes in when we take him to the hospital knowing it's just getting him back onto his medications hoping maybe a 302 for a day or two to get him, and they couldn't keep him because he wasn't a threat to himself or somebody else. As a result, one of my other officers would end up dealing with him later in the day or the next day, and it would escalate. And then it would become where we would have to arrest. So I agree that it certainly needs change. It puts us, law enforcement, in a bad situation when you know, especially in your neighborhood, you know who they are, you know what they're capable of, and you know what they've done in the past, and it's almost like our hands are tied. Thank God we now have crisis intervention training, and so many officers go through that we can recognize this and try to de-escalate it and at least get them there. But if we can't get them the treatment they need once they're there, we fail. So I agree with you wholeheartedly. Certainly is something that needs to be corrected and changed. Thank you.
Absolutely. And if I can add, it's not as if we would have to reinvent the wheel. There are jurisdictions that have AOT programs in which individuals have been identified, and they come up on reviews every 6 months or so in terms of how well that individual is doing in the AOT program and the community. And if that person is not going to their appointments with their psychiatrist or the mental health clinician in the community, if they are found that they're not taking their medications, and some of these individuals are placed on long-acting medications that prevent them from skipping daily oral doses, but once a month or so they go to appointment, have their treatment. If they don't go to those appointments, that person can be picked up and taken and to be evaluated emergently. And if they're doing fine and re-engaging that person in treatment, then it's great. One of the problems with the way that we have our system, as I mentioned earlier, is the follow-up after the person. There are too many folks who get lost to care in the way our system is. Even if we connect them, even if we do it through this process, the therapeutic jurisprudence, eventually, and if anyone has been a public defender or prosecutor here knows this, that there are individuals who have frequent touches with the mental health systems, behavioral health systems, and law enforcement. We can identify those individuals, as other jurisdictions have, and build programs around those individuals to be able to assist. Because the cost that would be spent in the community to do this thing, to create this thing in the community, we're already spending that money. We're just spending it in the wrong place. We're spending it in the correctional facilities, in places where it's not an ideal delivery of mental health services. We're not doing a great job of providing clinical treatment for individuals in a correctional punitive setting. We have judges and attorneys trying to direct care because they're sort of the last stop, right? And is that what we want to do? So the costs, they're being spent in a different place. They're being spent with the time of judges and attorneys working in the courtrooms around these things, where the police officers who are going back and forth to emergency departments, picking up someone, dropping them off, doing the cost is already being spent. But we're not getting, our returns in terms of individuals having a better quality of lives and not being incarcerated.
And if I can just add, Doctor, an alternative could possibly be too is through telemedicine. We've talked about this with counseling sessions. Those counselors will know through those sessions when they see a patient starting to go south, and knows that they now got to do a face-to-face because they're starting to see something. So even to ease it on the patient, not having to be at that office and be there on a regular, but they can do it through telecommunications. And then if it gets to that point, as the counselor would sense, would require them to come in, is maybe an option we can look at too.
Yes.
Thank you.
Yes.
Can I just,
Of course.
how you spoke about law enforcement and law enforcement going back and the need to, I think a lot of times about sort of the first touch, right? The first touch with a system. And a lot of times it can be law enforcement. And the notion of, I think a lot about too, sorry if any of us has ever been to an emergency department, right? It's chaotic, it's fast, it's not always comforting, right? And so sometimes a lot of times, once you're there, they're trying to get you out. And I think a lot of times too about, somebody's first experience with a mental health crisis and, how a person is received. And this just always makes me think more and more about crisis services and whether crisis services, involve training for law enforcement. And I'm so glad that you brought that up.
Yep.
And also, though, the ability for there to be a system that can very early on receive somebody in a comfortable way and provide them the very first care that they need, which includes education for their family members, some support for the family member, bringing them in. And also, again, I can't help but talk about peer support, right? The belief and the hope that your life can be different from that very initial point of crisis could be life-changing for people. To know that somebody has walked in those shoes. I have a mental illness. I have schizophrenia, and I'm working here today. I work, 40 hours a week. Could be enlightening for a family member, for an individual, and could really alter the course of somebody's life.
I just want to follow up on what Dr. Watson said. There's no reason why civil people shouldn't know about the number of police calls to that house, the number of commitments, all of this information, and be required to take it into account as to dangerousness. I mean, we know there's plenty of frequent flyers, as we used to call them. Constantly, police know, DAs know. This isn't humane, what's going on. And the other part is it's going to also take money in terms of having facilities and let's be honest, they emptied out the state hospitals, said, oh, we're going to have community residential facilities, and we didn't really have them. And the ones we had, I wouldn't say were very effective. So why do people wind up on the street homeless? The point is that we've got to have a structured system. I keep going back to that, and including things that help on the civil side before they ever have to come to the criminal side. And the truth is, everybody sort of dismisses it. It's low level, it's nothing, it's harassment. Harassment leads to the homicide, unfortunately. And people who are not taking their medication, where there's a history, where there's problems decompensating, or all of a sudden have a mental illness that's pretty serious, you gotta have better ways to get them into civil treatment to stabilize them.
And if I could just add a remark also. I mentioned this briefly earlier, but I don't want to get lost. I don't want it to get lost in the sauce because I think it's so important. When someone's admitted pursuant to a 302, most times they are released within 5 days with a court order. It ends up being an order by the hearing officer that's approved by the court for outpatient treatment. And I really do believe, and then there's no follow-up. And I really do believe if there was some requirement that they had to come back, so many of these people have no one in their lives who give them support. Their families have given up on them. And if there even is just a hearing officer that cared, if they knew they were coming back and had to answer to a hearing officer, I think right now in behavioral health court, I had a young woman very early on. She came in, I interviewed with her, told her she needed to do X, Y, and Z. She came back, she had done what she needed to do, and I told her, well, I'm proud of you. You did what I asked you to do, and she burst into tears. So, of course, my first thought was, uh-oh, what did I do? And she said, I've never had anyone in my life tell me they were proud of me. And it became clear to me and to the treatment court team that this was somebody who no one had ever said, good job, you did it. And we don't have that on the civil side with the assisted outpatient treatment, and we could.
Thank you. Representative Hohenstein, did you have a comment or question?
Yeah, thank you, Chair. And thank you, Chair Kaufman and Chair Briggs for having this. And Whip Schlossberg, this is really good work, and I think it's a good start to this conversation. I represent parts of Philadelphia, Kensington, the River Wards, Frankfurt, places where substance use disorder is the rule of the day. And actually, the folks who live with that are controlling and occupying large swaths of the neighborhoods that I'm in. And I think this balance between the service and care for the individual and the safety of the community is going to be one of the most essential pivot points that this potential legislation that might come out of this, or any of the suggested policies that come out of this. And I will say I fall squarely in the camp of recognizing substance use disorder as a medical condition, as something that is treated and can be treated, and from which people can be in recovery, and they can return to society that we know. I think what I would like to see in some of this, and as I looked at the stakeholders, one thing I recognize that we are going to need to do is add in the people who are going to be in charge of the payments for the medical services, the insurance companies, the agencies that address those issues as well, because how those payments are structured and what treatments are authorized and approved and accessed and can be accessed relatively quickly, it's going to be essential to have the type of response that we need, both individually for a person in crisis, and then also collectively for the neighbors and the people who are living in fear of going out on their front steps. As an example, back in city of Philadelphia right now, my council person is presenting an entire bill that would limit how do we provide services to people who are homeless, who are living with addiction on the streets. And her focus is that many of the way that we have delivered those services has been counterproductive, both for the individual, but then also for the communities that they're in. So if any of you, feel that you can speak to that dual balance between individual and community, how are we going to be looking at that as we look at these potential changes?
Thank you. I think that that will be a difficult question. I think that we're all going to be wrestling with, and I think we often wrestle with, in terms of the point that you made around insurance companies and reimbursement and all these important issues around costs. One of the things that I like to remind some of my students is that that mental illness and substance use disorders are all together with that. I include is just as valid as any other physical medical condition. Unfortunately, mental illness has a stigma, and has for a long time a stigma attached to it, along with substance use disorders, as if there's some sort of moral related value one way or other, an issue of morality versus this is a medical condition. I like to remind my students that just as your lungs have a problem, your heart has a problem, the brain is an organ as well, and it can have problems. And it, like asthma, you have difficulty breathing. If you have asthma, you will have difficulty thinking if you have a problem with the organ that is in charge of thinking, right? And we should be treating it the same and considering it the same as a condition, to have these artificial disparity in terms of the way that we fund things and the way we approach things in terms of health. Is problematic, and I think that we have to do a lot of work around that. It gets complicated because we also have these legal-related issues, right? A person has the ability to choose, right? Their autonomy, and we have to pay attention to that. And what point does it tip the scale into we are now jeopardizing this individual, even though that individual can't see it in this moment, and we're jeopardizing the community. I can only, from my perspective, reflect on the individuals that I've sat with, homicide defendants, who I have either opined that they were not responsible criminally because they were so severely impaired at the time that they did not know the difference between right or wrong. And when they were engaging in that behavior, that degree of severity of mental illness. And for anyone who doesn't believe that that is something that is possible, when we talk about delusions, delusional ideas, these individual folks who are suffering that believe what they believe, just like all of us believe we are sitting here in this room right now, doing whatever it is that we believe we're doing. They believe it like that, and you're not going to talk them out of any of it. And then you treat them, and they're sitting in a correctional facility having done something terrible, and sometimes, and tragically, it's to the parents who are usually the ones who are the last ones to give up on an adult child, in the cases that I'm involved in, right? And they're sitting there in grief because they never in a million years would have acted this way, but for the beliefs that they had at the time that they were not treated. Right? So this is a very serious matter. I would argue that those individuals that I sit with, if they had the time back and they could say, hey, listen, don't listen to me then, right? I'm not thinking clearly. I need help. And they would have asked for that help, and they would have asked for that intervention. I don't know if they would have, at that point, been advocating for my patient rights at that time or my autonomy at that time, in the balance of what happened to their loved ones instead.
I think it's an issue of civil liberties, and we have to balance, as the representative is talking about, do people have a right to just be on the street screaming at people and acting certain ways? Unfortunately, I think that we got to figure out how to make cities or towns appropriate for people to live in. We have that. It's a huge problem in Philadelphia. In Center City, a block from the courthouse, there's constantly people lying and screaming and yelling at people and things like that. They obviously have mental illness to be doing that. I acquitted somebody on an insanity defense. It's very rare. They shot at a house. But I had that person for 10 years under my supervision on a civil commitment. That's a different thing. You got to have some structure that will supervise and make sure these people are taking their medication. Most people have an insanity defense, and I've had others where I haven't, or juries haven't. It's a very difficult because it's guilty but mentally ill is usually the default verdict in Pennsylvania. But the point is, without structure, it's the civil system doesn't have the teeth. How you put the teeth in that to make sure people follow up and are required to, and if they don't, what happens? We do follow up in the criminal side. We put them in jail. We have them come back to see us. We work with them. We encourage them. There's a lot of things you can do. And a judge, because they hold the keys to the jail, can do more things. How the civil system will do it, that's one of the challenges I think that you face, because most people recognize, including public defenders and prosecutors, that the civil system is very, very ineffective. And there's got to be ways to put more teeth into it.
Thinking having payers at the table and sort of some of the payment structures as well. I think that there were some changes to the act before where I think there was some thinking that there were no costs, and I think that it's important to understand what actual costs might be relative to changes in the act. The system, unfortunately, is very complex in terms of payment structures. There are some things that cannot be paid for, only medical and clinical services through insurance and through Medicaid or Medicare. where other services such as housing and residential get paid through by funding that comes into the counties from the state. Sometimes you have to even do a blend. Some of our most intensive residential programs, Medicaid will pay for the treatment part, and then the county, through the county dollars that come in through the block grant, pays for the room and board. So it's just very, very complex, and I think, you know, before changes to the act are made, it's good to sort of think through what those financial impacts are as well.
And with respect to that, in terms of what actual costs are, I think we also need to recognize benefits that come when we have earlier and more comprehensive intervention prior to crisis. And I think being able to point out cost benefits that come from reforms is going to be a real important point when we have to have the final conversation about where the votes are going to fall with a reform legislation as well. Thank you.
Thank you, Representative. I think we were just about to conclude. I just want to thank you all by myself and the committee for being here and talking and sharing with your experiences. Very valuable testimony. Whip Schlossberg, do you have any closing comments?
Just a sincere thank you. This has been really illuminating.
Thank you very much. This meeting stands adjourned.